Now the lecture on the pill and judicial activism in ensuring justice and social equity. To deliver a presentation on the particular topic, we have invited Mr. Anubhav Kumar, practicing advocate at Supreme Court of India. Mr. Anubhav Kumar is an advocate in Supreme Court of India with a robust portfolio of experience. He has been a part of several important cases. His areas of interest include comparative constitutional law, judicial processes, criminology, and environmental justice. With this brief introduction, now I request Mr. Anubhav Kumar to deliver his presentation on the topic given. I welcome Mr. Anubhav Kumar.
Thank you. Thank you so much. First and foremost, I express my gratitude that I am invited here to give a lecture on the topic role of PIL and judicial activism in ensuring justice and social equity. So before I start this presentation or lecture, whatever you may call, this I just wanted to flag that this will be more like anecdotal experiences and whatever we have understood how PIL conceptualized in India and how courts have these days been working on frivolous PILs which are being filed, which is the major issue right now with public interest litigations and how courts have been reacting to it. So I'll just try to break down first of all the first essence of my the first phase of my short lecture is to break down the topic itself. Public interest litigation, as Sir in his introduction has clearly and most vividly, in a very lucid manner, explained how they emanated in India, is essentially because of the dormant nature of the courts in the very beginning of the independence. So by that I mean to say that when India got independence in 1947, and then we had a constitution making process, and then the Supreme Court and other constitutional court came into existence. At that point of time, the idea of interpreting constitutional values or constitutional ethos was construed as a tool to be only used in terms of black letter law written in the law or the law books. And there was no per se flamboyant judiciary or any judges who were doing some extra, going extra mile and interpreting constitution to enforce or give what is the next limb of the topic called justice. At the end of the day, justice is actually, law is actually an handmaiden to justice, because law is set of rules. I'm making a very generic statement, but at the end of the day, we have to understand that law is working as a tool or a machinery to have an effective administration of justice itself. An effective administration of justice needs the constitutional courts or otherwise the local courts of the country to take a hyper, not even if not hyperactive, an active role in interpreting the constitutional values. So PIL and judicial activism, as in the sir said in the lecture in the introduction also, are intertwined itself. How do we get over the fact? How do we understand what exactly is judicial activism, and is it a correct term to be used? So for that, we need to understand that judicial activism is, in my opinion, nothing but right form of interpretation of constitution, which is somehow by the originalist interpretation of constitution felt like a perverse form of judicial review. That's the whole whole long and short of how judicial activism is viewed. But for that, we need to clearly understand how a state operates, how laws operate in a country, and how at the end of the day the court's interpretation is going to impact the people of the nation. For that, I'll just take you back to how actually a state has been formed. Because so there is a very popular theory called social contract theory, in which there is Jean-Jacques Rousseau's interpretation, there is Thomas Hobbes' interpretation, John Locke's interpretation of how a state is formed. But in all of those, a common thread which we will see all together is that the people's will has to be taken as a superior thing. So people's will has now in Indian constitution context been interpreted or been imposed or superimposed through constitution as we read, we the people of India, and thereafter that interpretation's job, that wills to be implemented, has been given to the job of a judiciary. So judiciary is to do that interpretation and ensure that people are getting justice, ensure that people are at a social standstill where everyone is equal. If not equal, then as the equity principle is followed, and that the wherever is the lacuna in the government itself, the judiciary comes up and fills that lacuna, and so that a healthy and liberal democracy with all sort of constitutional values, economic values, and environmental values and social values is reinforced. Now having given you that a small basis of what the topic is and what how introduction of PIL and judicial activism is viewed in India, we need to now go to the main issue of today's presentation, is that how courts have used PILs as a tool to enforce judicial act, ensuring justice and social equity in country. And for that, the long shot has always been an environmental jurisprudence development. So if you see environmental jurisprudence development in India, you will see a parallel with judicial activism and public interest litigation. And that is more so because there was a time, again, which has been discussed in the introduction, there was a time when the courts were dormant and they were just doing whatever the executive was asking them to do. They were obliging to it. There were dark days of democracy. Sorry. I think someone is on. Am I audible?
Yes, sir. You are audible, sir.
Am I audible? Yeah. Sorry.
Yes, sir. You are audible, sir.
Correct. So basically, the redemption of judiciary coming with Maneka Gandhi and etc. was a tipping point of how PILs have been introduced in this country. Then, all thanks to all justices like P.N. Bhagwati, V.R. Krishna here, etc., who have been instrumental in developing our constitutional values, which is now we see in environment jurisprudence these days. So, and then it has gone on to such level that today, I mean, a few days back, we were involved in a Great Indian Bustard case. One of my friend was involved in a Great Indian Bustard case in Supreme Court. If you remember, it's an endangered species. It's a huge bird which can actually fly, and there was a transmission line issues where they were flying, but they were not able to, and the transmission electricity line were creating hindrances, and a lot of Great Indian bustards were dying. And in that case, the court has actually gone on to interpret that, right to having a safe and secure environment is actually now your fundamental right, and right to having a right to not have an adverse impact of climate change is also fundamental right. So from 1975, where PILs were not even existent, and environment was just like the international agreements were what were governing our environmental laws, we have come across till here. And this is all because of how PILs have played a great role and been instrumental in those. But has PIL or public interest litigation only be a way to enforce social equity or environmental rights? For that, I'll just take you through some case laws. And the first of all, which I wanted to discuss, is Municipal Corporation Ratlam versus Vardi Chand. So that is a very important case in the history of environment, because it emanates from not any constitutional court. It emanates not from any constitutional article. It emanates from simple 133 CRPC, where you can write a letter to the deputy magistrate of your region for whatever the issue is regarding that. And that's what the issue was. There was a lot of dust and garbage around them, which was not being taken care of. And V.R. Krishna took that judgment and took that issue and gave a splendid judgment to us. And from there, we have understood that, okay, right to life and livelihood cannot only become from a constitutional value, a constitutional article, but also from from random articles of CRPC. I mean, not so random, but very less used articles of CRPC. So that is one of the cases which has been a trigger point or tipping point of environmental jurisprudence. But what exactly is PIL? After understanding this, we need to understand how different is public interest litigation, because I assume a lot of people are from non-law background also. So public interest litigation, I'll try to explain in a very simple terms, is a non-locus based litigation which is preferred in constitutional courts of India. In constitutional courts of India, we mean the high courts, which are around 24 or 25 in the country, and the Supreme Court. And the respective articles are Article 226 of the Constitution of India for High Court and Article 32 for the Supreme Court. And these articles are very variedly used these days for various reasons. But since that we are trying to understand how PILs came in picture, we also need to understand 32 to 26 is always read in culmination with Article 21 also, because a lot of issues are involving under Article 21, a lot of issues are involving Article 14, 16, 19. So those are ways, or those are paths or passages how 32 PIL or 226 PIL has taken its own course and has seen light of the day right now. And a lot of cases are there. If you go on to read, one of them will be a very fair series of cases called MC Mehta cases. And I'm pretty sure a lot of people are aware of how and who is MC Mehta. But though MC Mehta cases, let's say MC Mehta versus state of Tamil Nadu, which relates to child labor, people or children of less than 14 years of age should not be working in fire and other mine and mineral industries, which was a landmark case, which went on to become a huge basis for how rights of students or children is to be looked on, and how their working rights has to be regulated, and so on. So that it has now traveled to different countries also. Then there are environment cases of MC Mehta, Taj trapezium case, Delhi pollution case. Taj trapezium case is one of the very famous cases where PIL has been used, in sense that today the yellowishness of the Taj was concerned there, and buildings or the monuments has to be preserved came from MC Mehta versus Union of India, the Taj trapezium case. And then there was MC Mehta versus Union of India in somewhere in 1990s, where we see the pollution cases were to be taken care. Like the courts actually started playing a huge role in controlling how the pollution should be tackled. So and that is so much so that today also in courts we see varyingly at every day we see in court number 5, court number 6, where the green benches are designated in Supreme Court, that we see a lot of MC Mehta cases still going on for cutting off trees, felling of trees, and then there are a lot of development authorities cutting trees. Those cases are still going on. And then there came a time when in 1990s there was this T and Godawaran case also came into existence, deemed forest cases. Those all relates to environment and PIL itself, and so that these T and Godawaran cases are still pending in court. I mean, by pending, I do not mean that the constitutional adjudication has not been done. It has done. The laws has been settled, but the recourse of having a secure and good environment is such that people are still filing miscellaneous applications and IEs in the intervention applications in the closed cases of T and Godawaran and etc. And they are still being taken care of by the courts. So the role of court is extreme in implementing environmental protection per se with PIL. But the second limb of it is social justice, rights of people. And as I explained in one of the cases of MC Mehta, where child labor was taken care of by the court. And then there is two judgments which I would want to highlight. One of them is being Husainara Khatun, and another one being Vishaka case. These two cases are also a very important landmark in our judicial development of how PILs have been viewed upon, because Husainara Khatun was a judgment which came from Patna, and it was a case related to under trials in Patna who were long incarcerated, but the trials were not being taken care of, and there was almost 4,000 people were released on basis of that, and right to free and fair legal aid was introduced in that, and that's what also coming. That also came from public interest litigation. Then there was a Vishakha versus state of Rajasthan, a horrendous case where rights of the working women was to be was not to be sexually exploited was enforced by the constitutional court, and then it was in 2013 made a law, prevention of sexual harassment at workplace. So much so that the PILs have played a great role in our constitutional adjudication and how laws has now been interpreted. But would we call it as a judicial activism, which is a perverse form of judicial review, or it has all been done in the four blocks of constitution? In my understanding, judicial activism should not be considered or should not be taken or viewed as something which is a perverse form of judicial review, or otherwise extra that the courts have gone extra mile from what it was required from them to do or give justice. Because at the end of the day, when you are doing a constitutional adjudication, you are to interpret constitution in a sense, with constitution, which by the way is always a living doctrine which develops with time. You have to interpret the constitution in a way that your liberal constitutional values are enforced, and people, especially who are living in a lower strata, downtrodden, actually get impacted with positively, and their rights are enforced. So in my humble understanding, judicial activism is still a form of judicial review only, which is very well within in the rights of which is very well within in the ambit which is defined for the courts to decide a constitutional case. Because I am pretty much aware of how sometimes courts can go berserk and try to go into the horizons of executive or otherwise legislature. But in these cases, the courts have never made laws per se, in the sense that somewhere that a legislature has been enacted by them. It has not. It has only filled the lacuna which was already existing through their judgments, and which are sometimes called as legislative judgments, but otherwise are actually very well within the ambit of it. So public interest litigation per se is something which has contributed richly in the India's constitutional jurisprudence, and it has impacted a lot of people. It has taken a lot of people out of the downtrodden society, and has made a great marks in social activism itself. And then it has also been instrumental in cases where it has interlocked with governments. Let's say the SP Gupta case, where the appointments of judges were also, as at an interlocking place, where the courts actually at the end of the day decided that it should be in consultation, and consultation means that the Chief Justice of India's concurrence has to be taken. So what I'm trying to put forward is that with all these cases which we see right now, which we have seen in the history, the borderline or the thin line or the thread running through it is that the rights of the people should not hamper, and the courts have played extremely generous role in doing so. But with advent of this, there is always a curiosity, or there is always a curiosity amongst people to check how far a court can go. And that can lead to some kind of influence where public spirited people can take step back, and publicity spirited people can come forward and start filing a frivolous PI, public interest litigations, which has now started to dampen the strength, or had started to clog the judicial backlogs in Supreme Court and the other high courts of the country. But in my personal experience, and otherwise my professional experience of how I have seen these days, the courts are very, there is no set pattern of how the courts have been looking at the PILs to admit it or not. But the court has been able to garner out of it if it is a frivolous litigation or not, because they have started being a bit of conservative, in the sense that they want you to take a similar route of going to high court and then coming to Supreme Court. And this is just one of the safety mechanisms so that they don't get overburdened. And the question of laws which can be decided by, even in the PIL, by the high courts should not come to the Supreme Court. So that is one of the measures which courts have started taking, and that was fairly discussed by Sir in the introduction. And then the second issue of it is that the people are to be made aware, because in a personal experience, again, it's an anecdotal experience, because I studied in Dehradun, and there was a huge road in Dehradun which was actually encroaching, and people encroached the roads per se, and there was a public spirited person who was just writing letters to the High Court at that point of time, in the High Court of Nainital, if I'm correct. And that has how Nainital High Court exercised this epistolary jurisdiction, and there it actually used the letters as a petition, and took it as a public interest litigation, and actually developed the law on that, and decided the case. So what the point is that even if there are no set standards of how PIL is being treated, the courts are still very generous and understanding, in the sense that they know what they are doing, and they have exercised restraint rightfully in some cases, and they have gone on to decide in favor of people who are from different backgrounds and have impacted the life of people and environment, and has richly contributed in the economic or environmental growth of the country. And at the very end of the day, I would just like to highlight one of the cases which we saw, which was very celebrated these days, was the demolition case of bulldozer justice coming from Uttar Pradesh in India. And the Supreme Court actually decided that this business has to stop, and rule of law is actually the only supremacy of law. It would be of rule of law. And that was also series of writ petition and some of suo motu petitions, and where the writ petitions were converted into PIL, and there was this law laid down ensuring social and environmental justice of the people. So all in all, the courts have been the courts have been very acceptive and receptive towards it, but it has always been marred by the executive's interference, and how strong executive is, and how the executive is responding to it. That's how the courts have actually taken care of the public interest litigations and all. So the question still remains how PIL to be countered, but few steps have been taken. There are wonderful developments of law, question of law being decided from public interest litigation. So all in all, this is how today we are placed, and the future of public interest litigations, if not ended, I mean, probably it will not never be ending, but a bit of it is in a conservative shell, and that's how where people should also be taken care of and be aware, and that's where the suggestion of Sir, which was in introduction, would come in handy. That the courts exercising restraint should also be which also be married with principles which people should be aware of. So yeah, that was pretty much what I wanted to talk about, and hopefully I've been able to contribute positively in this. Thank you.
Thank you, Mr. Anubhav. I express my heartfelt appreciation for your remarkable presentation at our event. It is very good, actually. And Mr. Anubhav has come up with some of the important cases which have been brought under PIL. And he has also mentioned some of the judgments with regard to PILs. And he also opined that the public interest should be protected. And he has also focused on our Hydra issues also while interpreting the PIL. And as far as the PILs are concerned, he has talked about the positive aspects of PIL. And there will be some questions. I have received one or two questions so far. We will take the questions at the end of the second presentation by Gautam Kumar. Thank you, Mr. Anubhav.
Thank you so much.
Despite your busy schedule, just you have attended and you have presented very nicely today.
It's my honor, sir. Thank you.
Thank you. So I have received nearly 6 to 7 questions. Due to time constraint, just we will limit to 3 to 4 questions. My first question to Mr. Anubhav Kumar. the practicing lawyer at Supreme Court of India. As far as the fundamental rights are concerned, the fundamental rights are guaranteed in Article 12 to 35 of the Constitution. So our participants would like to know whether the accused and the prisoners, people and the prisoners, whether they can enjoy all these fundamental rights or not. So what are the various rights of accused and prisoners?
Yeah. So under Part 3 of the Constitution of India, it's very clear that the prisoners or accused, the fundamental rights is enshrined, and it's pretty clear that who the Part 3 applies to. So I think so Article 14, 19, and 21, there are all three of these applies to the all person, if you see the word person. And some of the articles apply to citizens. Article 32 applies to all persons. So in my fair understanding, there is no qualifier as such of an accused person or I'd say a prisoner who is not entitled to a fundamental right. And anyway, so in criminal law, we know that a person until unless proven guilty still is innocent. And the accused itself, the word terms means that he's just accused of a case or of any offense per se. So that does not change the status of the person. There are some rights which are curtailed. I think so, voting rights and other things which are anyway not fundamental rights. So those are there, but otherwise I don't think so there's any specification of curtailing of fundamental rights of people who are in category of accused. There may be some limitations of jail and other authorities, but the fundamental right per se is not curtailed.
Okay, thank you. That one more. Whether there is any difference between public interest litigation and private interest litigation? Just to throw some light on private interest litigation.
I'll give an answer to this with an example actually. So the day before, closing of the Supreme Court, which was around 18th of December for the vacation. I think so a week or so before of it, I was in Chief Court, and there was this one case which was filed to remove the word socialist and secular from PIL. From preamble, my bad. From preamble, and the Chief Justice of India at that point of time dismissed it in saying that it's a frivolous litigation you are doing because we don't know what to do because there is no basis of it. So there, I think so is an example of private interest litigation. So these days, what is happening is that because of the live streaming and all those of things which have come into pictures, you are easily in a place where you can be in a spotlight and be recognized in media. And media has also started to cover courts rigorously and more vehemently. So you are always in news. So those kind of things which do not have any substance in it and are just filed on the behest of any other political party or any other intentions, those are the private interest litigation, in my opinion. Public interest litigation, even these days, as I discussed in my presentation, the courts have started to get very conservative, but they are still open to substance. I've seen that firsthand with a firsthand experience. What they are necessarily doing is asking me to go to the High Court because they also are a constitutional court. Otherwise, I don't think so there's any difference on those. But yeah, public interest litigation and private interest litigation are very different because some people have actually made a whole career out of it, of private litigation. We are terming as public interest litigation. So those things are there, better not said on this platform.
No, it is clear, sir. It is clear. Conclude the session. I express my sincere gratitude to Mr. Anubhav Kumar and Mr. Gautam Kumar for their participation at our event. Both of their presentations were informative and thought-provoking. We look forward to collaborate with Mr. Anubhav Kumar and Mr. Gautam Kumar again in the future. We also thank Dr. G. Vanishri Madam from IBS Bangalore, Dr. Kesari from Faculty of Law, ICFI Foundation for Higher Education, and students of BA and MA Economics of ICFI School of Social Sciences, and other participants for their participation in the webinar. And we thank the Sakshi management of Sakshi Media for giving us this opportunity to conduct the webinars. And we also thank the in charge of Sakshi Education, Mr. Chaitanya Kranti, for giving us this opportunity and his active participation in conducting the webinars successfully for the last 2 months. Thank you, one and all. Thank you, Mr. Anubhav and Gautam.
Thank you so much, sir.
Both of your presentations were very good.
Thank you, sir. Thank you.